Welcome to Google class. How are you, students? Today I am going to discuss with Indian Penal Code. Here the special topic we already discussed with section 304 last video class. Now same the continuation of the earlier video. Judicial Dilemma. What is judicial dilemma? I'll give you based on this section wise. 302 or 304 judicial dilemma. Okay. The Indian Penal Code was enacted in the year 1860, under which the offences within the territory of India have been tried ever since it was enacted, dealing with the countless number of cases leading either to acquittal or conviction. Yet, the task of the decision-making authorities, that is courts, whether an offence of culpable homicide is murder or culpable homicide does not amounting to murder in the prevailing facts and circumstances of the case, is perennial question with which the courts are often confronted. When the evidence discloses a clear case of murder or makes out a finding of culpable homicide not amounting to murder, the task of the courts to record conviction or acquittal is generally an ICE one. Okay. Generally, yeah, easy one. Okay. Easy one. But this task surely becomes an undaunted one when the accused commits culpable homicide or murder, but the circumstances disclose many a times that it is done without premeditations or pre-planning, maybe to cause grievous hurt. Yet it is so grave in nature that it results into death, and the role of the factum causing death without premeditation becomes a secondary consideration, due to which the decision of the courts in such cases often hinges on discretion while considering whether the case would fall under section 302 IPC or it would be under 304 part 1 or even part 2 of IPC on a plain reading of section 299, section 300, section 302, section 304 of Indian Penal Code. It appears that given cases can be conveniently classified into two categories, that is culpable homicide amounting to murder, which is 302 IPC, or culpable homicide not amounting to murder, which is 304 Indian Penal Code. But when it comes to the actual application of these two sections in our given cases, the courts are often confronted with dilemma as to whether a case would fall under section 302 IPC or would fall under section 304 of IPC. Many a time this gives rise to conflicting decisions of the one court or the other, giving rise to popular perception among litigants and members of the bar that particular court is an acquitting court or is a convicting one. This confusion or dilemma often emerges in a case when the question of consideration is whether a given case would fall under section 302 of IPC or 304 of IPC, when it is difficult to decipher from the evidence where the intention was to cause merely bodily injury, which would not make out an offence of murder, or there was clear intention to kill the victim, making out a clear case of an offence of murder. Section 300 states both what is murder and what is not. First finds place in section 300 in its four stated categories, while the second finds detailed mention in the stated 5 exceptions to section 300. Okay, we have section 305 exemption 1 2 3 4 5 we already discussed last video classes. Okay, and ingredient section 300 1 2 3 4. Okay, that is subclass 300, subclass 1, subclass 2, subclass 3, subclass 4 is available. So in this time the 300 in its 4 state categories. Okay, the second finds detail mentioned in the stated 5 exemptions to section 300. Now it clear. The legislature, that is parliamentary, in its wisdom thus covered the entire gamut of culpable homicide that amounting to murder as well as that not amounting to murder in a compromised manner in section 300 of the code. It is neither advisable nor possible to stage any straight jacket formula that would be universally applicable to all cases for such determination. So every case essentially must be decided on its own merits. The court has to perform the very delicate function of applying the provisions of the code of the facts of the case with a clear demarcation as to under what category of cases the case at the hand falls and accordingly punish the accused. Okay, this is the nature of the court. Okay, and parliamentary enacted these above sections and all. Let's see a few cases based on this above sections. We'll discuss a few cases here where the accused husband, suspecting the fidelity of his wife, quarreled with her. Then he poured kerosene on her body and set her on fire, and subsequently when she screamed for help, tried to extinguish fire by pouring water. In this situation, the case was discussed before. Supreme Court held that he was having full knowledge that his act would cause her death, and the attempt of extinguishing the fire will not mitigate the offence. Hence, he was liable under section 302 of Indian Penal Code and not under section 304 of Indian Penal Code. Okay, and another one example where the deceased, an old man with an enlarged and flabby heart, was lifted by the accused during a quarrel and thrown on the ground from distance with sufficient force, and the deceased got his ribs fractured and died of a rupture of the heart. It was held that the offence fell under section 325 of IPC and not under part 2 of this section. Part 2 of this section means 304 subclass part 2, not under this. Okay, as the accused had no intention or knowledge to cause death. Okay, this was saying example. And another example, the accused stabbed the deceased in a sudden incident during an election fever. During the election, the time election fever is happened, no? So which resulted in his death 4 days later in hospital where he had been operated upon, in which resulted in his death. Okay, a bit to save his life. There was no evidence that the accused intended to cause death or cause such bodily injury as was sufficient in ordinary course of nature to cause death. In the circumstance, it was held that the case fell within class 299 subclass B of IPC. It did not fall, okay, within class section 300 subclause 3 of the IPC, and as such his conviction under section 302 was set aside and he was convicted under section 304 subclause part 1 of the Indian Penal Code. Okay, this type of situation also occurred. The court, based on the situation circumstances, passed the judgment. Okay, now it's clear this portion. And another example where a death of a player was caused by blowing a cricket stump on him in a friendly cricket match. It was found that the accused player did not know that his act would cause an injury which would cause death or which was likely to cause death. It was held that a conviction under section 304 subclause part 2 was not proper, but that an offence under section 325 of IPC was made out as the injury was caused by a stump which is a blunt weapon. Okay, and another reference case studies. A married woman nearly aged 25 years met a sudden death in her matrimonial home. Matrimonial home means is a husband house. Her letters and complaints spoke of harassment. The medical report put the cause of death as a rupture of spleen and pancreas caused by external pressure. Her husband, who was attempting to escape by resorting to the theory of death by poisoning, was found guilty, and his conviction under part 2 of this section. Part 2 of this section means 304 subclause part 2. Okay, section, and sentence of 5 years of rigorous imprisonment was upheld by the Supreme Court. Okay, though he might not have intended to cause death, he did cause an injury about which he must have known that it might cause death. Okay, this is what saying court gave judgment also. Okay, now it's clear about section. Okay, I will give you cases under part 1, section 304 subclause part 1, where the accused, with the intention of obstructing the marriage of his sister with the deceased, gave only one blow which proved fatal, and the accused did not repeat the blow through. There was nothing to stop him. Okay, here conviction and sentence of the accused under section 302 was altered to under section 304 subclause means part 1. Okay, and another example where 3 accused person assaulted the deceased. One of the accused gave the fatal blow on the victim's head. The second accused caused simple injuries on the knee and arm with spear, and the third gave simple blows. It was held that the first accused was liable to be convicted under section 304 subclause part 1, and as section 34 was not applicable, the second was convicted under section 324 of IPC, and the conviction of the third accused under section 323 was upheld. Okay, now it clear? And one leading case, Arendranath Mandal versus State of Bihar. The death essential to attract section 304. Here, the accused caused injury on the head of man with back portion of his weapon. The injured survived the injury, Still the accused was convicted under section 304 subclause part 1. It was held that the accused could not be convicted under section 304 because for the application of section 304 death must have been caused under any of the circumstances mentioned in the 5 exception of section 3. Okay, so here section 300 exception also we must check whether it is come or not. After that only the court will giving conclusion based on the circumstance, based on this injury. Okay, so these are all main things to observe, and as per the Evidence Act and inherent power of the court also. Okay, and another thing, okay, we'll close this session. We'll meet you again next video class. We'll discuss regarding cases under part 2. Only cases. We already discussed the ingredients and all. Cases under part 2 of 304. Okay, please wait and see next video class. Okay, I will give you a good tips means the illustrations and any other examples also. Okay, bye, thank you.